February 20th, 2007. Sorry. Unfortunately, I have to leave, so I'm going to hand the meeting over since Nancy Harder is in LA this evening, I believe, for a funeral. And so it becomes up to the three of you to run this meeting. May I nominate Annette Cordero, since you have done it many times before? And
Let's see, do we need board action on that? Well, let's vote anyway, just to,
all those in favor?
Yes.
Oh, do we need
No, it's already moved and seconded.
Okay. All those in favor? Aye.
Aye.
good, thank you. Enjoy. Bob Noel moved.
Should we slide down?
I'll just move over here.
Yeah, I think that's fine.
Okay, well, the meeting has already been called to order, so we can just start with the flag salute.
Very good.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have translation tonight provided by Alma Flores.
Buenas noches, mi nombre es Alma y estoy aquí para traducir para ustedes.
Gracias, señora. Okay. We have headsets for the hearing impaired, if anybody needs them. We have almost no one in the audience, but public comments. Is there any members of the public who wish to speak at this time? Hearing none, we will move on to our conference agenda. The first reading of modifications to Administrative Regulation 5144.1, suspension and expulsion due process.
This is a topic that we've talked about for quite a period of time. I know that there are some others who would like to be part of this discussion as well, and I'd like Mr. Gonzalez to explain that as well as to review what the proposed modifications are. Mr. Gonzalez is our Director of Compliance and Categorical Programs.
Thank you very much. Late this afternoon, we received an email from the Santa Barbara Teen Clinic. They were advised very late that this item was going to be on the agenda, and they've requested an opportunity to have input. They have suggested that the board take no action on this item tonight, and as soon as we know the next meeting, if you agree, we'll make sure that they are informed very early so they can have an opportunity to comment. What we have in front of you tonight is the Administrative Regulation 5144.1 on expulsions that reflects the 16 recommendations that the board approved on January 23rd. I should also add that this proposed administrative regulation also takes the existing administrative regulation and makes it compliant with the upgrades to the education code that pertains to expulsions and suspensions. The changes are underlined, and I think very quickly, if you'll permit me, I'll just go through the sections that gives you a sense for what the modifications are. I'm looking at page 1 of 18, and about 3/4 of the way down, that particular item defines the terms used in expulsions, and you can see that we've added language that gives a definition of what a stipulated agreement is. If you go on to page 3 of 18, you're going to find items P, Q, and R. These are additions to the education code of grounds for suspension expulsions. P, for example, says unlawfully offered, arranged to sell, negotiated to sell, or sold the prescription drug Soma. Q talks about engaged in or attempted to engage in hazing as defined by Ed Code section 32050. R talks about making terroristic threats against school officials and school property and defines what terroristic threat is. It continues on page 4. Page 4 of 18, there was some additional wording that reflects the Ed Code. For example, under S, you can see it says committed sexual harassment. Under T, you can see that we added Ed Code section 223. Under U, you can see that we've added district personnel or students referring to harassment, threats, and intimidation. If you'll go to page 11 of 18, Section B at the very bottom speaks to the administrative hearing panel and its composition, reflecting what the board wanted. It goes on to the next page, top of page 12. On page 13, it continues with some new language for the administrative hearing. Specifically, I'm looking at section 4 on page 13. It says the following: the hearing officer or administrative panel shall, within 3 school days after the hearing, determine whether to recommend expulsion of the student to the board. If the student is not recommended, the student shall be immediately reinstated, and then it leads you down to the reinstatement section. E is what I wanted to bring to your attention: stipulated agreement alternative, voluntary consent to discipline. And the very last line, again, it defines for the district, for the public, what a stipulated agreement is. And if you go down to that very last sentence of page 13, this reflects one of the recommendations that was made last month. It says parents and students will be given a waiting period of at least 1 week in advance, and it continues on page 14, in advance of signing a stipulated agreement. Also, the next sentence says parents will be encouraged to consult with an attorney prior to signing an agreement if the parents are unsure of the provisions of the agreement. And then boilerplate language about making sure it's in compliance with education code and subject to final approval by the board. The next section reflects what we have generally called a supplemental hearing. And if I could direct your attention down to the second paragraph, I'm looking at section F, called Final Decision by the Board. And take a look at the third paragraph, actually. And it says as follows: when a supplemental hearing is requested, the board will consider the request at the time which is scheduled for the board to take action on the expulsion recommendation, and will determine in its sole discretion whether to grant or deny a supplemental hearing. A decision of the board to order a supplemental hearing may limit the scope and time for the hearing, and condition the granting of a hearing upon the agreement of the pupil and parent guardian to waive any time requirements that may be applicable. In addition, in lieu of conducting the supplemental hearing, the board may order the supplemental proceedings be conducted by the administrative panel. One more paragraph, if you'll permit me. It goes on to say, if the board accepts the recommendation calling for expulsion, acceptance shall be based upon a review of findings and recommendations submitted by the administrative panel. And again, this reflects the recommendations that the board has agreed to. Please.
Those are the recommendations of council, aren't they?
Well,
you said the recommendations the board has agreed to, but I just wanted to underline, they're recommendations by legal counsel, aren't they?
There are recommendations by staff and legal counsel, correct, that the board approved at an earlier meeting, correct. Okay. The rest of the language on page 14 at the top of page 15 reflects existing Ed Code language that was missing from our previous AR.
Madam President, okay to ask him another question at this time? You don't need to wait.
We're through with the presentation, so
Okay,
you're welcome
yes,
to
go ahead.
ask.
Back to page 14, section F,
Right.
third paragraph.
Mhm.
When a supplemental hearing is requested, the board will consider the request at the time which is scheduled for the board to take action on the expulsion recommendation. That, for me, I have images of families already here waiting to see whether they're going to be heard or not. It all happens the same evening? Or will the board make that decision prior to, and then once it's decided to hold a hearing, the families would be told there'll be a hearing?
The way this AR is currently written, the first scenario, if I wanted a hearing before the board in disagreement with or additional information I wanted to provide the board before they made the hearing, I would submit a letter to the district requesting such a supplemental hearing. At the closed board session where the administrative panel presents its recommendation, that request for a hearing would be heard under the way this administrative regulation is written, and then the board would determine, yes, we agree, and schedule that meeting at a future date.
Oh, at a future date?
Yes, at a future date.
That's what wasn't clear to me. I
Right.
had pictures of the family being there waiting, and the board saying, well, we're not going to, we decided not to have the hearing,
Right.
and the family and the witnesses or attorney or whoever else.
The
So the-
just
Well, is that the part that addressed, I think in the middle of that paragraph, it says the decision of the board to order a supplemental hearing may limit the scope and time for the hearings and condition the granting of the hearing upon the agreement of the pupil and the parent or guardian to waive any time requirements that may be applicable.
correct, and that's a
So it may-
critical.
because it's likely to extend the time frame under which all of that will occur.
And yes, it would extend the time frame, and we're subject to a 40-day completion process. And so, yes, it's very important that a parent waive that particular right.
Thank you.
Additional questions or comments?
I've got a few, if you don't mind running through my list.
Please.
On page 3 of 18, unlawfully offered, arranged to sell, negotiated to sell, or sold the prescription drug Soma. Why does that need to be spelled out, Soma, as opposed to just other prescription drugs?
Without sounding facetious, the education code is sometimes has quirks, and I do not know the logic of why Soma was specifically delineated as something that should be contraband at our schools. All I know is that indeed this does reflect existing ed code. It's Soma, as you may know, is a muscle relaxant, a very powerful muscle relaxant. And again, I don't know the logic behind the State Board of Education and staff at the CDE approving that this go into the education code.
Okay.
That's not at all facetious.
No.
It's surprising, isn't it?
Just a minor point on the language on the first page. A stipulated agreement can be entered into where there is no disagreement about the facts or the law and where the offense is expellable. It made more sense to me to use when than where in those situations, if people are amenable to that. Then on page 8 of 18, when we're talking about the involuntary transfers, students may be involuntarily transferred by the superintendent or designee. And what I wanted to know is, what do you mean by designee? Is it at the district level? Or are you talking about principals? Just because I'm a little concerned when you're talking about involuntary transfers, is this something that's going to be, I don't know what existing practice is. I don't know what's going on
My
right now.
designee has been the assistant superintendent.
So right
One of the
now, if
assistant
they need to
superintendents.
come, if they're going to do an involuntary transfer, it has to come to the district, to an assistant superintendent. I think that maybe designee needs to be a little bit clearer that it's at the district level.
Well, but that language occurs all over the place in our policies, superintendent or
Or
designee.
designee.
Oh, everywhere,
Yeah.
yeah. But
Right.
but you're right, I mean, it's.
But as long as, maybe I guess as long
Or
as.
his designee, or
or-
her.
Is, as long as there's some policy that some AR, I guess, or just an exhibit of what the principals are told that they need to do, that gets tied to it, so that we know that these
So that we
involuntary
show those
transfers are,
guidelines
that they
and-
get
Well-
reported to the district.
I think Ms. Parker's got a really good point, but I look at it a little different take. This policy does not mean the principals can make that decision outside of below the district level. I mean, I take it that's part of your concern?
I think so, as long as it's by the superintendent or designee. I guess a lot of times, I feel like the designee is often a principal in certain situations, and since there's, not in this particular one clearly, but in other parts of our policy, sometimes it says superintendent or designee, and sometimes it's things that happen on the site level. Something to be concerned about or nothing to be concerned about? I don't know, because I don't know what's going on right now.
Well, why don't we address what's going on right now? I mean, do these cases always come, in fact, let me turn to the assistant superintendents. Do these cases always come to you? Are they ever handled internally, maybe between principals at schools or something like that?
That was on page 8.
In the secondary district, they all come through me,
Uh-huh,
and we have a discussion about it.
okay.
That would be the same at elementary as well.
Okay.
It happens less,
Mhm.
often, but it has happened a couple times since I've been here, and it always comes to me.
Okay. Okay. So if that's.
Well, I was wondering if we wanted to put in parentheses, usually assistant superintendent, but then, as Bob just said, this kind of language occurs throughout our
Yeah,
policies.
so no, I mean, consistency is, if that's the way it's done in the rest of the policies, then I think it's important to keep it the same, just as long as we're clear on what's going on.
I would like to see clarification along the lines of Ms. Parker's saying. And specify her or his designee. So the
Yes.
concern that I see is simply that it not ultimately somehow get confused that this power goes down to at the principal level and stays there. And the concern is that principals, I don't think, should have a unilateral ability to do a unilateral transfer.
Well, we could insert her or his designee.
Whatever language
What-
to do that job.
Does that address your concern, Ms.
Um,
Parker? Because I thought your concern was who the designee is. And Bob,
It
Dr.
is.
Noel's concern is who gets to designate. And so I think saying his or her designee would indicate that it's the designee that the superintendent appoints.
Uh-huh.
But it still doesn't say who the superintendent will appoint.
Right.
And so I was wondering if that gets at your...
Yeah, generally, the superintendent has a line of authority.
Mm-hmm.
And if one of us, for example, was on an extended leave for medical reasons,
Right.
there would be the next person in line of authority that would
Right.
be the designee.
Yeah.
It gives latitude, actually, that kind of
In
language.
fact,
So-
that language, the ed code is replete with that phrase.
Yeah. I think that in that case, that yes, his or her would improve it, but it would still give you the latitude to go outside the bounds if you needed to.
Well, we can certainly insert his or her.
On page 11 of 18, item D at the top, the governing board shall order a pupil expelled upon finding that the pupil committed an act listed in subdivision 3A, 3B, 3C, or 3D. I wasn't sure what that meant, because the previous 3 that I see is 3, the involuntary transfer procedure, where is subdivision 3A, 3B, 3C, or 3D?
You are correct. I'm looking at that, and it does not seem to be proper, and we'll have to relook at that.
I
Yeah.
bet you those are references from an earlier draft. That since has now been moved around.
Okay, so if it's, maybe it's C 1, 2, 3, 4, but that would need renumbering. And then finally, for me, on the top of page 12 of 18, when it's talking about the impartial administrative panel, this panel will normally include one retired administrator, and here's one where I think it might be beneficial for the district to have a little bit more flexibility, and maybe say may include one retired administrator instead of will normally. So that would just be a suggestion there. So those are my comments on that.
May include a retired administrator.
Yep.
Typically
Yes,
will?
that way it could, well, not typically, but just may include a, and that way you have some flexibility on the number and
Sure do.
what, if somebody's there or not.
Thank you.
Dr. Noel, did you finish your comments, or did you have others that you?
All finished.
Okay. I had a question regarding, I think it's under F on page 14, where we were a minute ago. The fourth paragraph. If the board accepts the recommendation calling for expulsion, acceptance shall be based upon a review of the findings of the fact and recommendations submitted by the administrative panel or upon the results of any supplemental hearing conducted pursuant to law that the board may order. Let me finish. Let me read the next sentence, because I just wanted to make sure it was clear. A decision by the board to expel a pupil following a hearing shall be based upon substantial evidence relevant to the charges adduced at the hearing, except as otherwise allowed by law. No evidence to expel shall be based solely upon hearsay evidence. This paragraph comes after the paragraph about requesting a supplemental hearing. And so when it says if the board accepts the recommendations calling for expulsion, that sounds like it's going back to if we do it without having the supplemental hearing. But is this saying no matter where in the process, whether it's before the hearing or after the hearing, just at any point, acceptance shall be based upon the review of the findings of fact and recommendations submitted by the administrative panel or upon the results of any supplemental hearing conducted pursuant to law that the board may order. So I guess I was just a little bit confused about the chronology of that.
What this paragraph attempts to spell out is that regardless of how the recommendation comes to the board, either through an administrative hearing or a supplemental hearing that the board chose to conduct, that hearsay evidence is not, a district could not expel a youngster on the basis of hearsay evidence. The definition of hearsay evidence, paper.
Okay, so the whole first part of that is basically just saying no matter how we get wherever
Correct.
we decide,
Correct.
it just can't be based on hearsay. Okay.
Would
May I make a,
would you like some language to clarify that? Yes.
well, it's
Yes.
just, to me, I think there's even a typo. It says, except as otherwise allowed by law, no evidence to expel shall be based solely upon hearsay evidence. Shouldn't that read, no decision to expel shall be based solely on
No,
hearsay evidence?
no.
Yes.
In fact, hearsay evidence is almost a contradiction of terms.
Yes.
No decision to expel shall be based solely upon hearsay.
Yes.
Good.
Ms. Cordero, was there some further clarification that might help?
I was just wondering I'm wondering if I'm trying to make this too simple, but I'm wondering if we could just get to the last part of it and not have the first part of that paragraph. Just basically say, no decision shall be based on, no decision to expel shall be based solely on hearsay.
Well, or start with the second sentence, a decision by the board to expel a pupil following a hearing shall be based upon substantial evidence.
See, I think where I was getting lost is all about the hearing and the recommendation from the panel and the
How about-
supplemental. What if we just said a decision by the board to expel a pupil
A pupil.
shall be based upon substantial evidence? Because we're only going to
Yes.
be making the decision whenever the process is done.
So omit the language following a hearing.
Right. And just a decision by the board to expel a pupil shall be based upon substantial evidence relevant to the charges adduced at, or relevant to the charges, except as otherwise allowed by law, no decision to expel shall be based solely upon hearsay.
Mr. Gonzalez, can
But-
we go without that first sentence altogether? In that
We'll make sure that council has take a look at it, but yes, if it's not necessary, we'll delete that first sentence of that paragraph.
Okay, and if council thinks that we do need it, I would recommend maybe doing it the way that Dr. Sarver suggested and move the pertinent point up to the beginning
Ahead.
and then follow it with what we do need to base the decision on.
Thank you.
Okay. I think that was, I had a couple of questions that were covered by Ms. Parker. I think that was the only one of my additional questions. So, how does the board feel about delaying action on this
Well,
item?
Actually, we put the conference items on first, thinking that there'd be more public interest in attending those items, so this is only on for
Oh, this is only on
conference
conference.
and
Okay, you're right.
discussion.
Now,
You're right.
there are lots of little typos.
Uh,
Is it okay for
Have
board members
you-
to email?
Have you located typos that you'd be happy to share with us?
Well, I could, but I could also just email them. It's things like
Wonderful.
Yeah,
misspellings and.
I agree.
you know.
Thought we could maybe do that rather than taking board time.
That would be
Thank
wonderful.
you.
Meeting time to
Thank
do
you.
that, okay, thank you. As long as it doesn't substantially change the meaning of anything.
Yeah.
Okay. Okay, then we can move on to item B2. First reading of proposed board policy and administrative regulation 1312.5, complaints concerning district employees.
This is also on for discussion tonight, and making the presentation will be again Michael Gonzalez, our Director of Compliance.
Thank you. The need for this particular board policy and administrative regulation stems from an employee that had intended to file a complaint and was searching through our board policies and administrative regulations for a way to voice this complaint. As you know, our board policies, the board has adopted uniform complaints that alleges that is used when there's an allegation of discrimination in a state or federally funded program. We have the Williams complaint procedures that addresses instructional materials, facilities, and highly qualified teachers, but we did not have a general complaint procedure that an employee could use. In researching, we found out that several years ago, the board had adopted board policy 4344 that outlined a resolution procedure, but limited its use to management employees. And so with that, we have put together this administrative regulation and board policy 1312.5 that permits employees to file a complaint and have it processed. Essentially, it's a four-step process. One is a very informal, get together with the supervisor or principal and work it out informally. If that process doesn't work out, then it takes it to the next level, a more formal step one. And in this step, the complaint is filed within 60 days of the allegation of the complaint, the subject of the complaint. The investigation is conducted by the employee's immediate supervisor or the principal. They respond within 5 working days, and they investigate within 5 working days and provide a written response to the employee within 10 days. If the employee is not satisfied there, they take it to the next level, which is filing a complaint with the board, or excuse me, with the superintendent or his designee within 5 working days of receiving the response in step 1. The superintendent or his designee would investigate and provide the employee a written answer concerning the complaint within 10 days. The next step involves the board. If the employee was dissatisfied with the response from the superintendent's designee, the employee could file a grievance, a complaint within the board. The hearing would be held in closed session. If it's a matter appropriate for a closed session, the board would make its decision within 30 days, and the board's decision would be final. This is the process that we believe, staff believes, will permit any district employee to file a complaint without using inappropriate administrative regulations.
I had a question about the informal process. The discussion of the informal process, well, first of all, it says, formal complaint procedures shall not be initiated unless informal efforts to resolve the complaint have been exhausted, which suggests that there's a number of things you might do. But under the policy, under board policy, informal conference, which excuse me, I'm assuming is meant to be the informal process, identifies speaking to your immediate supervisor. And I'm concerned about that, and I also wonder if that's even, if council has looked at that, is it legal for us to require that a person has spoken to their supervisor before they make a written complaint? What if the supervisor were the person they were complaining about?
That's a very good question that I don't have an answer for, that we should run by council.
I thought I saw language that circumvented the supervisor. And
Well,
said that
there
you
was
can
for
go-
sexual harassment.
Oh, was that?
Yeah, an employee is not required to resolve sexual harassment complaints
Mhm.
with the offending person,
Oh,
That's
okay.
correct.
but not in general. My question is this CSBA language? Is that where this board policy came from?
Correct.
Well, we can research that.
Well, just in general have a concern about requiring employees to go through an informal process before they're allowed to exercise what I understand to be their rights to file a formal complaint if they want to. I mean, I certainly wouldn't object to encouraging employees to exhaust informal processes, but I'm not sure I would like to go so far as to require them to go through an informal process before they're allowed to file a formal complaint.
I agree with you. And take a look at page 1 of 3. Under informal complaints, employees are encouraged to resolve complaints informally. Formal complaint procedures shall not be initiated unless informal efforts to resolve the complaint have been exhausted. And
See,
that's
that's
the
the part,
section.
that's the part that I'm
Very
concerned
good.
about.
Okay.
Yeah, they are encouraged to is great.
And maybe it could also include a description of what they're
What the
encouraged
informal-
to do.
yeah, what the informal-
Conference with, that, that sort of thing, but
You can't have both.
Well, we can
Well,
encourage.
You can't encourage, which implies that someone may not accept the encouragement, and then require it.
Otherwise, it would say employees are required to resolve complaints.
Well, certainly requiring it is a very strong form of encouragement. But I agree. They do seem
Yes.
we'll
at
bring-
odds with each other.
We'll bring back 2 versions, one that describes the informal complaint procedures, and then another one that simply deletes that reference to having to do it.
Okay.
Okay?
I'm assuming other board members
Yeah.
agree with that. Great, thank you. That certainly addresses my concern. Okay, are there any other questions or comments on this item? Okay, hearing none, we will move on then to the action agenda.
Thank you.
Thank you. And I want it noted, we are exactly on time. That-
Despite starting late, that's pretty impressive.
Yes. Second reading and adoption of new board policies on mission, goals, and plans. Board policy series, I don't know what these are called.
This
The
is
zeros.
the 0000. This is on mission goals and plans. We've reviewed these at previous meetings. In fact, this all started some 1 year ago, I believe, when we had a couple of board members go over these policies. We had our own internal review then. We brought these back to the board at, I don't remember which meeting. January 19th. Very good. Thank you so much. Yes. And we then went back to Ed Code language because we wanted to double check on a couple of these. For instance, the language on charter schools had significant changes in Ed Code language in that intervening year. So we went back to Ed Code language, and I'd like to acknowledge the work of Barbara Kiani, who's with us tonight, by the way, in double checking word for word what we had in this language versus what was in the Ed Code. The process on this would be to eliminate the existing board policies on school-based coordination program, charter schools, review and evaluation, and our annual report card, the school district's annual report card, since there is substantial amount of change in each of those policies, and start afresh with these policies that speak to mission, the philosophy of the district, setting the goals for the district, our comprehensive plans, non-discrimination in our programs and activities, our school plans and site councils, our school-based program coordination, charter school policies, comprehensive local plan for special education, comprehensive safety plan, accountability, and the district's efforts in school accountability report card requirements. So you have the policy language before you. The underlined parts are changes either from our last meeting or that came to us from updated CSBA policies and updated Ed Code language.
Are there any questions or comments? Yes.
Sure. Couple things. One is there are minor typos. There's only one that I would like to call attention to right now, and that is
Yes.
on Administrative Regulation 0430, elements of the local plan. This is about the comprehensive local plan for special education. Item number 4.
I'm sorry, is that board policy or
It's
administrative?
Administrative Regulation.
Administrative
sorry,
reg, okay.
0430, comprehensive local plan for special education. It's on the second page, number 4. A description of the method by which members of the public, including parents, guards of individuals. That one, I think, should be changed to guardians.
Thank you.
And my other comment is on the comprehensive safety plans, the administrative regulations, looking through those. And this is just because I don't know, I haven't seen a school safety plan yet in my board career.
You're about to.
I'm about to, and I'm excited about it.
Just wait till next week.
But because the board policy and the AR, it doesn't really go into what I would think of as some of the nuts and bolts, which are things like how many fire extinguishers and first aid kits and defibrillators that we have, things like that. And is that something that we will see in the site safety plans when they come to us one by one, or is that something that?
Yeah. By way of the elements of a safety plan?
When I look at the elements, nowhere does it call for, we need to present that we have X number of fire extinguishers per square foot,
No, we
or
simply-
we have this number of first aid kits.
We simply
for-
follow code on the number of fire extinguishers. Maybe we should have Mr. Gonzalez address the elements of the safety plan, because This has been in process for a long time. We have various requirements. It was difficult to pin the state down as to what the elements were that were required. We've gotten some recent updates on that, and we've used those updates to build the newest school safety plans.
Thank you. In reference to your concern, the safe school plans that you should see at the next board meeting will not specify how many fire extinguishers or defibrillators or gallons of water there are at that particular site. But you bring up a very important point that I want to share with you, is that the Ed Code spells out what should be included in a safe school planning document. And just to give you an overview, it talks about look at existing data. Are the schools safe? The data that you've got, where does it indicate there's a problem area? It also requests that schools plan for an evacuation of the school and what all that means, as well as if an emergency requires that students stay at that campus, stay inside their classrooms, what we call a lockdown drill, what are the procedures for that? What we have done with our school sites is we have sent them documents from the Red Cross that took recommendations about what kind of supplies schools should have based on Red Cross data that they took a look at after the Northridge earthquake. But again, the plans that we'll present to you do not specify. However, we are in the process. I need you to know that the plans, to make them fully operational, will require supplies that the schools currently have in short supply or do not have. We are requesting from each of the principals, tell us, what do you need in order to make that plan operational? That data will not be available at the next board meeting, but it'll come to you subsequent to that. We have to know, I'll give you one small example. We have a junior high that has multiple programs at that campus, and we've come to find out that only the school, the comprehensive school, has radios that communicate within their staff. These other programs that coexist on that campus do not have access to radios. Another example, which is pretty universal, almost every classroom has a system within the classroom to communicate, but the hallways and outside the grounds, we do not have a way to communicate in the event of emergency. That information is being gathered for you.
Well, that's exactly the question I was going to ask, and I was going to piggyback it on Ms. Parker's. My concern specifically had to do with communication and the fact that it isn't specified in the board policy what kind of communication would exist. And I don't know if I was sort of reading this into Ms. Parker's question as well, but have mixed feelings about relying solely on the sites to say what they think they need. I also think that we should, at the board level, set some standards of what we think is necessary in order to ensure school safety, and then perhaps ask the individual schools to supplement that list or tell us if there are certain equipment that they need in order to implement what we have said the standards are. But for example, the issue of communication really concerns me, given that so many of the schools have very large campuses where people can be in many different parts of the campus, many of which are workshops or outdoors that would be difficult to reach. And I think the one you mentioned regarding communication between different programs, and especially as we look at perhaps housing, even different schools on the same campus, to make sure that they are always in communication with each other, or can be in the event of an emergency. So I don't know if that
It certainly
connected to your
it does
concern as
tie
well.
into it, in the sense that you'd want to make sure that there is some standard, but maybe it's some sort of Red Cross standard that we're looking at. But again, would the Red Cross be looking at the fact that at a school site you need to have radio communication across all programs? I don't know if there's some model that we can look at that makes sure that all of our schools are at least working towards having the same safety level.
Ms. Parker just used the word I was going to ask. Is there a model? Is there a statewide champion school? we
No,
can
no,
model after?
there are quite a number of different models. And I think that the data that the principals will give you are a good way to begin. It'll give you a sense for what is available, what they believe is needed, and then we can talk about establishing district standards. But I think you'll find the information very useful in your deliberations.
So, I like the way that you just stated that. We can take their data and develop standards
Of course.
from it. So we will have a district standard. We can establish district standards, but it makes sense to establish them based on what the school sites have identified would be their needs. Okay, thank you, Mr. Gonzalez. Are there any other items that, I had one, just as I'm thinking about it, I don't know if anybody else has one. Excuse me. Actually, this occurred in a number of the policies, and I was ill, unfortunately, at the last meeting where the policies were discussed, so I didn't have a chance to have input into this, but I just want to thank Mr. Gonzalez and whoever else, Ms. Kiani, and anyone else who had input into drafting this language for including linguistic and economic background in our list of protected classes. And there were some others that were also, I think, that were added in that I think are very important. But I appreciate that those were added in. Thank you.
Good.
Okay. Does that bring us to the end of this discussion? Are there
I'm ready to make a motion.
not that I would like to extend it beyond unnecessarily. A motion would be delightful.
I move to approve with the very minor revision that was mentioned earlier. The new board policy, I guess, wait, do we need to get rid of the old policies first?
I think we can do it all at once, can we?
All
Can we
right.
do it all at once?
That is true, that we
All right, let us replace
replace
the old board policies in the.
As listed in the
As
agenda.
listed in the agenda, and add administrative regulations with the new board policies on mission goals and plans, board policy series 0000.
New policies and regulations? Great.
Yes.
I'll second that. All those in favor say aye. Aye. Opposed? Abstentions? Motion carries. And that brings us to the end of our agenda. We have, our next regularly scheduled board meeting will be next Tuesday at 7 o'clock. Do we have any additional comments or announcements to make, Dr. Sarvis?
No, we don't, we're not agendized for them.
Okay, that's true, we aren't. Okay,
Thank
so
you.
our next board meeting will be next Tuesday, and with that, we can adjourn the meeting.